assigned to handle this appeal on behalf of the appellant, Willie James Burton. I'm showing my age, Your Honors, so bear with me, but more than 40 years ago, I was in a situation appearing in front of the Temporary Emergency Court of Appeals, which was put into place by the Congress in response to the Arab oil embargoes in the mid-1970s. The case in front of me, the lawyer got up and said to the court, Your Honors, there are legions of cases on this, many, many cases. And the senior judge there said, Counsel, all you need is one good one. That's why we're here today. I have one case.
Okay.
This court's decision in Cavalier. Cavalier involved essentially this problem, although we think this problem here presented in this case is more egregious than what this court found in Cavalier, in which it reversed the conviction for child molestation. The problem we have here is that the victim, at the age of 12 years old, testified at the trial. At the very beginning of the state's case, towards the end of the case, the state offered into evidence video of the forensic examination, the forensic interview that was taken on the day of the alleged molestation.
It was a motion picture, a Hollywood produced motion picture, that wasn't it?
The other one was, yes, it was. This is even more serious. They show that video.
Why this is more serious?
Because this triggers the statute, Your Honor, the statute, which is 90.403, gives the various criteria for excluding.
It sounds like that means it's apples and oranges.
Your Honor.
That was a different question there, wasn't it?
Well, it was a video, just like we have a video here. The difference there was that video allegedly triggered the victim to come forward and make a complaint. Here, the video was actually the same testimony that the victim gave at the trial of the case in front of the jury.
That wasn't the only distinction in Cavalier. The Cavalier also, you have a detective testifying that he could tell that the child victim wasn't joking and treating the accusation seriously. He'd been trained to pick up on such things. It was blatant bolstering.
Well,
And that was part of what troubled the court, right?
well, that's what we contend here, Your Honor. This is
By
blatant.
playing a prior recording.
Well, this is the same thing, right? Exactly. This is bolstering.
Help me out how playing a prior recorded statement of a child that might otherwise be
Well, this is,
admissible child hearsay. Help me out, how is that akin and the same category as a detective bolstering that witness's testimony?
well, Your Honor, the statute 90.403, we believe, deals directly with the situation. It says relevant evidence is inadmissible if its probative value is substantially outweighed by the danger of blank, 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 needless presentation of cumulative evidence. So the question we have for the court is, we contend that the video that was taken, which is essentially the same testimony at 9 years old that the victim gave at the age of 12 years old, is cumulative evidence and was needless. There was no need for it. There was no challenge that was made to the veracity of that testimony other than cross-examination. So, in effect, the jury heard the same testimony twice. And that's what the statute deals with. And that's
I
what
need you
we...
to unpack that argument a little bit for me. There was no attack on the credibility other than cross-examination. I mean,
But it was still...
you pack a lot of attacks of veracity and cross-examination, right? I mean, that's the point
Oh, of course you can, but here's the issue, Your Honor. I know that at the last resort of this thing, the state's position in its brief was that, assuming that the video came in, it still was a harmless error, and that's the issue. We contend it was not a harmless error for the following reason. If you take a look at the verdict form that was given to the jury was given the option of finding the defendant guilty as charged on the main offense, which is a mandatory life sentence, which is what he got, or 3 lesser included offenses. So it wasn't as if we're dealing with whether the incident occurred. The question was 1 of the 10. And at the closing argument, defense counsel invited the jury to seriously consider a lesser included offense. So our position here today is we're not seriously contesting that there was some sort of interaction between the defendant and the victim. The question is what was in the defendant's mind at the time, as recognized by the Florida statutes. So what are the lesser included? One would have been an attempt to commit lewd or lascivious molestation by a person 18 years of age or older upon a child less than 12. Or the defendant could be guilty of battery, a lesser included offense. Or the defendant could be found guilty of committing an unnatural lascivious act, a lesser included offense. None of them called for life sentences. Within seconds after the jury returned the verdict, Mr. Burton was sentenced to a life sentence, and he's now confined at the Jackson Correctional Institution in North Florida. So our position here today is that the statute was triggered because this was a needless presentation of cumulative evidence. The exact same evidence was presented live. There was no need to present it again by video. So the effect, first, I wasn't in the jury room. I had no way to know what the course of the deliberations were. But I think it's, under the circumstances, we should indulge a presumption that something could have happened in the jury room, but they were inflamed or impassioned by hearing the same testimony twice and seeing the same testimony twice, once live and one by video, that they ruled out considering a lesser included offense. And a lesser included offense would not have included a mandatory life sentence. We believe under the circumstances that Mr. Burton did not get a fair trial, and that the judge unfortunately committed an error by allowing the video to come in and be published to the jury.
No, your cumulative argument is based on simply the fact that the incident was depicted or described twice.
Yes, sir.
But doesn't the statute presume that the testimony will be given twice because the statute presumes that the witness will be testifying?
But if you look at the child hearsay statute, which is point 803, they carve out an exception there for 403. So I'm not making any argument on 803.
You have to he was content with that, and in other words, you can't say that providing two different descriptions from the same witness about the same incident is per se cumulative, because the statute presumes that's going to happen, right?
Maybe, it's possible,
What is your best argument that this instance in which the depiction of the events was heard by the jury twice from the same witness?
Well, the argument is, when we noticed it was heard by the jury live because she was 12 years old and testified at the trial. If you compare the testimony at the trial with the statements that were made in the forensic interview on the date of the alleged assault, they're almost word for word with the same thing. The exact same sequence of events as to how it happened.
You might want to anticipate what the state's going to say, because they said in their brief that it wasn't the exact same thing. It was complimentary because there was gesticulations that described they depicted acting out what happened. Is that something beneficial, or is it at least something that undermines your point that it was the exact same testimony?
I don't have any, listen, I'm an advocate. I'm not here to give an impartial ruling on this. That's why your honors are here. So my advocacy is simple. It's the same thing. And your honors will have to listen to the state's argument. And
You said, you talked about the case in which there was a Hollywood movie that utilized by the state and the found to be illustrating the testimony. What is the case that, other than that, in which the mere duplication of the testimony was deemed to be cumulative?
if I told you, John, if I told you how much time I spent looking for cases that would support my position in this case, you would say, I became an old man just doing this case. This court's decision in Cavalier is the only one that stands out, which the court actually came out and said in very clear language that coming in and doing it, that video was prejudicial. I agree, it's not the same testimony completely. At trial in Cavalier, the victim testified that she had seen a television show, and as a result of watching it, she came forward and reported the matter to her parents, to her mother. There was no reason there for the state to show that video, and this court so held. So another question is, what was the reason why the state came forward and offered this into evidence after having had the testimony of the victim at the trial in front of the jury? And I'm not persuaded that there's any reason for that, other than to make sure the jury knew that this was a bad guy and he should get the maximum punishment for it. That's the only reason I can think of for it. There's nothing else that was added when they put on the video. So we ask that the court reverse the judgment and sentence that were entered below, send it back for a new trial. Thank you very much.
Thank you.
Good morning, Your Honors. May it please the Court, Crystal Kachi on behalf of the state. Picking up with what my colleague said about the bolstering argument, to say that the playing of the forensic interview in court is just simply unnecessarily repetitious flies directly in the face of 803 sub 23 because, as was noted by the panel, part of the foundational requirements for admitting this testimony is that the child testifies. So under his rationale, we can't go through an admissibility determination and then chop the prosecution off at the knees and say, no, you cannot play this otherwise admissible admissible evidence. Now, the state doesn't ignore that those statements, like any other evidence, are subject to 403. And so the state is saying, yes, that we heard the same story of the allegations, but first of all, as Judge Atkinson pointed out, the forensic interview testimony was complementary to the child victim testimony at the time of trial because of those demonstrative movements that the child made at the time. And not only that, the child participated in that forensic interview the day of the incident. So the jury was privy to hearing the story of what happened right when it did happen that day. And so that takes into account that from 9 years old to 12 years old, the child victim might have had some waning memory, so the jury was able to hear that testimony right when it happened. Now, in terms of bolstering, even though the state does not present cases like this in its brief, but Pardo is instructive here because we don't have a situation where we have a parade of witnesses coming in and repeating the story over and over again. We don't have a panoply of medical professionals coming in and just repeating the story and attempting to bolster the truth. So we would argue that the introduction of the forensic interview is not cumulative. It was complementary to the child's testimony, and to call this type of evidence bolstering would be incongruent to the plain language of 803 sub 23. So I'm happy to answer any further questions, but if not, the state would respectfully ask this court to affirm.
Thank you.
Your Honors, we have two statutes. The state comes in and says 803, I come in and I say 403. The problem here is that, in effect, the jury heard the same testimony twice. That's what we have to consider today. Is it fair for the state to present the same testimony twice? One at the beginning of its case, and then just before the jury goes out again twice. There's no need for that. The victim came in and testified, and the jury should have been allowed to make its determination as to credibility and the circumstances from that testimony. But this is just piling on. The legislature, in its wisdom, has, in effect, given to this court the responsibility of reconciling the two statutes. 803, we're not contesting the admissibility under 803 of that video. They went through all the preliminaries that were necessary to do it. But the real problem now is 403. Was it unduly prejudicial because it is a needless presentation of cumulative evidence? We say yes, the state says no. Thank you very much.
Thank you. All right, our next case this morning is Bradlin versus Melamio.